When I drove through the front gate of my ranch after a 3-day business trip, something felt wrong. The air was too quiet. Usually, I could hear water flowing over the spillway of my private reservoir from half a mile away. That sound was gone. I pressed the accelerator. As I reached the hill overlooking the reservoir, my stomach dropped. The water level had fallen by nearly 20 feet. Thousands of fish were trapped in shrinking pools. Mud stretched across what had been deep blue water just days earlier. Heavy pumps sat on the shoreline with giant hoses leading toward the neighboring HOA development. I couldn't believe what I was seeing. My name is Ethan Walker. My family owns over 5,000 acres of ranch land in Northern California. 30 years ago, my father legally built an $8 million reservoir to provide irrigation, livestock water, wildfire protection, and emergency reserves during drought seasons. Every permit had been approved. Every environmental requirement had been met. The reservoir wasn't just private property. It was a critical part of our ranch operation. Then came the HOA. 5 years earlier, a luxury subdivision was built beside one edge of our land. Its president, Karen Dawson, believed every nearby property should benefit the neighborhood. She constantly complained that our reservoir looked underused. More than once, she suggested turning it into a community recreation lake. Every time, my answer was simple: no. Apparently, she decided that answer no longer mattered. I immediately called my ranch manager. He sounded exhausted. Karen brought contractors yesterday morning, he explained. They claimed they had emergency authorization to lower the reservoir because they believed the dam was unsafe. My heart sank. I never proved anything. I know. They showed paperwork. Within minutes, I contacted the county water authority. Their chief engineer answered personally. His first words were chilling. We never issued any emergency order. That was all I needed to hear. I asked him to come immediately. An hour later, county engineers, sheriff's deputies, and environmental officers arrived at the ranch. Karen confidently walked toward them carrying a thick folder. She smiled as if she expected congratulations. Instead, the lead engineer asked one question: who authorized these pumps? Karen proudly replied, I did. The engineer frowned. Based on whose inspection? She hesitated. Well, our HOA consultant believed the dam looked dangerous. The engineer looked stunned. So you drained a privately owned reservoir without contacting the owner or obtaining state approval. Silence. The deputies immediately secured the pumping equipment while investigators examined the site. The truth became even worse. The contractors admitted Karen had hired them directly. She told them the HOA had authority because the reservoir was a danger to surrounding homes. Not one government agency had approved the work. The supposed emergency paperwork turned out to be nothing more than a private engineering opinion, not a legal authorization. By the next morning, state environmental officials arrived. The damage assessment was devastating. Thousands of fish had died. Protected wetlands downstream had been disrupted. Irrigation schedules for hundreds of acres of farmland were jeopardized. Local wildlife habitats suffered significant losses. The estimated damages climbed every hour. Television helicopters soon circled overhead. News reporters lined the county road outside my ranch. The story spread quickly. HOA accused of illegally draining private reservoir. Karen still insisted she had saved the neighborhood. But investigators kept finding problems. The contractors had broken locks, installed industrial pumps without permits, crossed private property lines, and ignored multiple warning signs. The county issued immediate stop work orders. Then came the civil lawsuit. My legal team included water rights specialists, environmental attorneys, engineers, and economists. Every dollar of damage was documented. Reservoir restoration, fish replacement, habitat recovery, crop losses, emergency water purchases, infrastructure repairs, future environmental monitoring. The total exceeded $12 million. Karen's attorneys argued she acted in good faith. The judge wasn't persuaded. During the trial, one piece of evidence changed everything. Security camera footage showed Karen personally directing contractors to bypass locked access gates before pumping even began. Then another recording surfaced. It captured her saying, If we drain enough water, the owner will have no choice but to negotiate with the HOA. The courtroom fell silent. That sentence destroyed her defense. The judge ruled her actions were intentional, unauthorized, and financially motivated. The court ordered Karen and the HOA to pay over $12 million in compensatory damages, restoration costs, and legal fees. The ruling also permanently prohibited the HOA from entering any portion of my property without written permission. But the consequences didn't stop there. State environmental agencies imposed additional penalties. Several contractors lost their licenses for failing to verify legal authorization. Insurance companies refused to cover intentional trespass claims. The HOA's reserve funds disappeared almost overnight. Residents were shocked. Many homeowners admitted they had never approved Karen's aggressive actions. Several filed lawsuits against the HOA board for mismanagement. Within months, every board member resigned. A court-appointed administrator temporarily took over association operations. Meanwhile, restoration crews worked around the clock. Water slowly returned to the reservoir. New fish populations were introduced. Native plants were replanted along the shoreline. Wildlife gradually returned. Nearly 2 years later, the reservoir looked even healthier than before. Today, it remains one of the largest privately maintained water reserves in the county. Sometimes visitors ask whether I regret taking the case to court. Not for a second, because this lawsuit was never about revenge. It was about protecting private property, environmental responsibility, and making sure nobody believes they can seize control of someone else's land simply because they think they know better. Karen thought she was draining a reservoir. Instead, she drained her HOA's future.